You want to go ahead and kick us off, Tad?
Sure. I want to welcome everybody to the crossroads of mediator ethics and interpersonal violence continuing mediator education presentation by the Florida Dispute Resolution Center. My name is Tad David, and Kimberly Kosch will be helping me today, or maybe I'll be helping her. Anyway, so just to get right into it, since we've only got an hour, as you see there, there are credits and materials. You can get the materials at the link. I think there was a link in your the invitation and the email. And also I believe a link, an email will be going out tomorrow that'll also have the materials. So, and you see that it's 1 hour of CME in both mediator ethics and IPV, interpersonal violence. Also, for Florida bar members, it has been approved for a program for 1 hour of legal ethics under the course number there, 220724N. So the purpose of continuing mediator education is to make sure and enhance the participants' professional competence and just function as a mediator. So this has long been a part of the Dispute Resolution Center's responsibilities and our goal. The CME continuing mediator education was instituted in 2000 with the requirement that county and circuit court mediators earn 2 hours earn 2 hours of domestic violence training every 2 years, and that family and dependency mediators earn 4 hours of domestic violence training every 2 years. So, but in February 2017, the Committee on Alternative Dispute Resolution Rules and Policy expanded the type of education that qualify for this to satisfy this requirement, and they renamed it from domestic violence to interpersonal violence. And interpersonal violence education includes 14 different topic areas and focuses on the safety and security of all persons involved in the mediation process, not just those within a domestic relationship. So and just to let you know, the DRC maintains a list of free CME programs on its website, and there are 15 recorded programs in the interpersonal violence category. And then of course, there are many other programs in the other categories. So as always, the DRC hopes to be a resource for stakeholders and practitioners and mediators. And so please check our website as often as you can. And we always try to put up useful information. And of course, it also contains these references for the continuing mediator education programs. All right. Now to jump into the substantive information for today, you see that, of course, under Section 44 in 44.102, court-ordered mediation shall be conducted according to the rules of practice and procedure adopted by the Supreme Court. So, it's not just throwing you out there. You've got to follow the rules of practice and procedure. I think everybody knows that. So, okay. But part of that is, as you see, that upon a motion or request of a party, the court has to refrain from referring the case to mediation if the court finds that there's been a history of domestic violence that would compromise the mediation process. Now, in here, you see that, this is not an automatic thing, but this is upon a motion or request of motion. And but a court is prohibited from referring the case if the court finds that there's been a history of domestic violence and that history would compromise the mediation process. So there are a couple of different elements in there that we have to look at to see if a case may not be suitable to be referred for mediation on the basis of a history of domestic violence. So, okay. And now, of course, when you see a statute like that and it contains a term, we look to see how that term is defined. And in section 741.28, domestic violence as you see, means any assault, aggravated assault, battery, aggravated battery, sexual assault, sexual battery, stalking, aggravated stalking, kidnapping, false imprisonment, or any other criminal offense resulting in physical injury or death of one family or household member by another family or household member. Now, it was this kind of limited or limiting definition of domestic violence that, a few years ago, I think, motivated the ADR R&P to change the focus of this of the continuing education from simply domestic violence and expand it to interpersonal violence, because as you see with domestic violence, it has to be these various violent offenses, but it has to be between a one family or household member by another family or household member. And what the ADR R&P realized is that there were situations that if there was interpersonal violence, if there was violence between people, even if they don't share, are not in the same family or do not share a household, that still may indicate that that mediation may not be appropriate, and that the court needed to take a closer look if requested to do so by one of the parties. Okay. And once again, this is going further to the definition of that's in the domestic violence definition of family or household member, and you see that it's a very limiting definition. And once again, this limitation is it was some of the motivation behind the ADR R&P expanding it a little bit, and the concept of interpersonal violence, because there are offenses and there's conduct that may not fit into the definition of domestic violence, because of the family or household member definition or other things that really, once again, would counsel against the appropriateness of mediation. So, okay. And is this one mine also?
Yes.
Okay, I thought so. I didn't want to jump in. All right. Now, except as provided in the section 44.405.1, all mediation communication is confidential. But what's very important is this exception, because it spells out the exceptions. And so if communication or and it can be nonverbal communication, other things, but if it does not fall under one of these exceptions, it is confidential. So and the confidentiality is laid out in subsections 1 and 2. And then the exceptions are enumerated in subsection 4A. And of course, at first it says, the signed written agreement, but generally I don't think violence is spelled out in a signed written agreement. So the most important one for this CME and that occasionally may come up is that if a statement is willfully used to plan, commit, or attempt to commit a crime, conceal an ongoing crime, conceal ongoing criminal activity, or threaten violence. Now, one important thing about this is that you see that it does not include past violence. If someone just reveals that they at one point committed a violent act, that is not necessarily does not necessarily fall under this exception. So we have to look very closely at what is being communicated and what is being revealed in that communication to ensure that it fits under this exception before that confidentiality does not apply. Okay.
Great, Tad. And I think I have the rest of the materials forward, but just to make clear to the mediators out there, because during their basic training and through many continuing education programs, I'm sure that they have heard trainers and experienced mediators stress that there are reporting requirements for mediators under Chapter 39 and 415 But that doesn't apply here, does it?
No, that I think those are referred to in a separate subpart or separate numbered part. I can't remember which ones those are. We may, but it's in there. Those are the reporting requirement is referred to in one of the other paragraphs in this subsection.
Right. But in essence, there is no mandatory report if a mediator learns about domestic violence, unless the violence has occurred in front of children and may fall under the purview of child abuse or neglect. But
right,
there is
that's important is that this exception only allows, even if something falls under this section, it then allows the mediator to potentially reveal it as only as necessary in this most limited fashion as they feel necessary, but it does not ever require them. It is never mandatory to reveal or to report. This is only a permissive exception here. And I think one of the examples that we use in from time to time is if you have someone threatening to commit suicide, and that is threatening violence. I mean, it's violence against themselves, but still, if something like that happens, it would fall under this exception and would allow the mediator, as I think most people would want to try to prevent that or assist this person, but at the same time, you would only want to reveal any information like that, any communication like that in the most limited fashion necessary to address and to either ameliorate or prevent the crime or the violence, etc. So, and
right.
One important thing is this is not this the third item in there says conceal ongoing criminal activity. It does not necessarily mean conceal criminal activity. So if somebody says they robbed a bank, 4 years ago, that's just information. That's, the information being given is not being used to conceal an ongoing criminal activity.
Right, great. And Tad, unlike the mandatory reports, which actually identify an agency, this subsection 2 doesn't give any guidance on, if you were to make the permissive report, who that report would go to. Right,
and like in the example we were just using, as far as the threatening, suicide or threatening, violence against the other person, I mean, it's still threatening violence. You would want to, according to the circumstance, whether it would be to just only to the judge initially, or, I mean, it's just really fact and circumstance specific. And, it's just a really sensitive and careful thing, because we have that overarching confidentiality in all mediation communication. So you really want to respect that confidentiality as much as possible, and you want to only want to reveal as much information as is absolutely necessary to prevent the crime or the violence, etc. And just for information, the paragraph that deals with mandatory reporting is the next one in line, which is 3. Is that the confidentiality does not apply to communication that requires a mandatory report pursuant to Chapter 39 or 415 solely for the purpose of making the mandatory report to the entity requiring the report. So both of those are very, very limited circumstances, and it is really easy when you're running through and reading these this statute at first to think that this is a much more expansive exception than it is. Both of these exceptions are very, very narrow, and we should always pause before making, revealing anything that you've heard or seen in mediation. Really, really need to stop. And I would always advise, go to the statute, look at it, make sure, okay, does this fit? Certainly for in certain circumstances for non-attorneys, you may even want to consult counsel. So
Okay, great. And Tad, just to remind everybody, you said it at the beginning, but just in case someone wasn't signed in, the materials have some additional information than the PowerPoint. And the link to those materials was in the email that you received at 11 a.m. this morning. You have to scroll to the bottom, though, unfortunately, to see that link. It was at the beginning, and we'll remind you where it is again so that you have the information that we're talking about right now is available to you. So thank you.
Yeah, and now are we using the Q&A function, correct? Not the chat function.
Right, and I saw that Mr. Cohen, we saw you out there, you raised your hand, but in the format that we're in for a webinar, we would ask you to put your question in the Q&A and to make sure that you put your name next to it. And if we don't have we will have an opportunity for Q&A. However, sometimes we receive quite a few questions and we're not able to answer them during the time allotted. Within the next week, Tad or I will follow up with every question that we've received if we're not able to answer it for you here. So if you can make sure to put your name, that'll help us find you and provide an email response to you. So we do appreciate your questions and comments. So, but before we get off this one, it's a good reminder to us, like just had said, before you start disclosing items that are permissive, to double check the statute. And if you have any questions, this presentation is being largely broadcast to court-connected mediators, and you have the wonderful luxury, every circuit has an ADR director. And I always think that they are your first line of defense and education and support. So if you do run into a situation where it's appropriate to bring in your ADR director for guidance, there's a good chance that he or she may have dealt with the issue before and could provide guidance on appropriate next steps. So
yes, definitely.
All right, great. I'm gonna take over and talk with you about the actual definition of interpersonal violence. And Tad gave you the history of where we have been and where we've come in the use of this term. And just so you know, in the statute, in the statutes that we reference, Chapter 44 is what I would call our foundational support for authorization to conduct mediation. The only word you're going to see is the reference to domestic violence that we went over with you in the previous slide. You're not going to find the term interpersonal violence. Perhaps that will change in the future, but interpersonal violence is defined in the operating procedures governing the certification of mediators. This document is fairly new and takes the place of predecessor administrative orders that have contained the same information. The Supreme Court has given the Committee on ADR Rules and Policy the ability to promulgate, sponsor, and amend different items related to mediator certification and renewal. And so that's hence why you're now seeing things in operating procedures compared to administrative orders, but largely the substance is the same. So interpersonal violence, like Tad mentioned, covers over 14 topics. So the ADR Rules and Policy Committee had back in 2016 received a letter from a former ADR director, Kathy Reuter, wherein asking if there could be a reduction of the CME hours in this component category. And the committee was very reluctant to lower the 2 and 4 hour requirements for some very good reasons. But in examining the requirement for mediators, what we realized and what they realized is that over time, other categories of items were just as appropriate for learning and education as domestic violence proper. And just limiting education to items that had the magic acronyms of DV might be shortchanging what the field needed. So that's why the CME was expanded. Now you will see that interpersonal violence does include domestic violence, stalking, repeat violence, dating violence, child abuse, child neglect, abuse of vulnerable adults. All of those items that I just read are all contained in different statutes. So there's a stalking statute, there is statutory references for repeat violence that is different from domestic violence. And we didn't want to spend all of our time on statutory reviews with you, but just to let you know that these items do have a strict statutory definition. You can, the way I find most things is through Google or other search engines. So you're happy to do that yourself if you like to find out more about the proper definitions of these words. Also included, and you might notice if you've attended our conferences, our past DRC conferences, that we have offered interpersonal violence education for a number of different topics, including human trafficking, animal cruelty, workplace violence, physical and emotional safety and security, trauma-informed responses, suicide prevention, awareness and risk factors, and self-harm, not suicidal. So I know that mediators come from a variety of backgrounds. Some of you may be degreed, educated, but not a member of a profession that requires licensing. Some of you are attorneys, teachers, educators, law enforcement officers, mental health providers, and you may very well have access to educational programs that fall within these titles, but aren't necessarily sponsored by the Dispute Resolution Center, nor might they actually be geared toward mediators. But continuing education is very much a self-empowering part of the renewal process. So if, for example, here in Leon County, one of our community partners was offering a workshop on human trafficking. It looked very interesting. Honestly, if I wasn't busy on that date and time, I would have attended. I could have used that course as CME, even though the provider wasn't advertising it for mediators, but it was on the topic of human trafficking. So if you take away, I hope you take away more than one thing at this training, but if you do take away more than one thing, if you thought that you had to continually take the same type of domestic violence training where you reviewed definitions, you looked at the power and the control wheel, or information had become repetitive to you on any of these topics, you are free to seek out and take classes on any of these topics. If you run across a course and you are unsure whether or not we would count it for continuing mediator education, whether it's in this specific area or not, we are more than happy at the DRC to look at the program. We don't pre-qualify, but we could certainly tell you whether this class would qualify or if it has qualified in the past. So again, you have a lot of resources. As Tad mentioned, we have a free CME guide on our website, and we have no less than 15 recorded topics in this area. And I believe that we have a recorded presentation on almost every topic. I believe we're still seeking out some good programs dealing with suicide prevention, awareness and risk factors, and self-harm. So I invite you to reach out to me if you do find a program, especially a recorded webinar that you've attended or you see advertised. If you think that it's something that would benefit the whole field, please reach out to me. My email and the DRC's email is at the end of the presentation. We would love your support in populating our resources with even more information. And we do partner with other OSCA units, especially our family courts and our problem-solving courts, when they do presentations on domestic violence and some of these other titles. So we are taking advantage of all of the education that our state courts units produce. So again, just make sure that you understand that you have a wide range of learning options before you.
And Kimberly, and I want to ensure that I didn't mischaracterize something. The expansion from domestic violence to interpersonal violence applies only to the CME requirement. It does not, and cannot change the committee can't change the statute. The statute still is as it's written and is based on domestic violence and domestic violence as defined in that statute. So I want to make sure that in my presentation of that expansion of the CME, that I didn't confuse someone to think that interpersonal violence had replaced domestic violence in that statute. So
right, thank you for that clarification. I think you were clear, but it
okay.
never hurts to clarify. So I like to think of interpersonal violence as focusing not so much on the relationship between the people, but a safe and secure mediation. So if you think back to the items that we just went over, and actually let me scroll back there a minute for you, because if we look at things like, for example, physical and emotional safety and security, we have focused a number of our plenary sessions since 2017 at our annual conference just on these topics of safety and security. So we had a 1-hour program where the marshal for the Supreme Court came down and did an active shooter training for us. This was pre-COVID, when most of us were in offices or in buildings conducting mediation, because having a plan for an active shooter, whether it's in a courthouse, a private facility, your office building, is always a good idea. I just kind of wanted to point out that again, things that you might not intuitively think fit in this definition have been counted. In addition, we have also counted cybersecurity. And many of you may have seen Christopher Hopkins. He's an expert in this area. He has not only conducted a plenary session for us in the past, but has offered a workshop, and he will be back this August offering another workshop in the cybersecurity area to make sure that we're all safe and secure in the electronics and the technology that we utilize. All right, so if we look at the rules for certified and court-appointed mediators, and we look to our obligations, and we think about an umbrella term of safety and security, it's worth reviewing what rules would actually impact safety and security in your mediation. So one of the bedrock principles of mediation is self-determination and party self-empowerment. So we start out with that rule, and it just requires that if any party is unable to freely exercise self-determination, a mediator shall cancel or postpone a mediation. And that shall is a must. That means you must do it. So if you have come to the conclusion in your mind that the party cannot participate meaningfully or exercise self-determination, the decision has already been made for you. You need to cancel or postpone the mediation. Confidentiality, Tad's already covered this in terms of the statutory requirements for confidentiality, but you as mediators not only have an obligation to follow all statutes, rules, administrative orders, court orders, and anything else we can think of, but you have an independent ethical obligation to maintain confidentiality of information revealed during mediation, except where disclosure is required or permitted by law or is agreed to by all parties. So again, be very careful on sharing information after the mediation, even with good intentions, unless there is a specific exception to confidentiality or the parties have agreed to it, you have an ethical responsibility to maintain that confidentiality. And we would hate to see mediators in Florida become entangled in a web of what they should or should not report, again, with good intentions, or perhaps mistakenly including it under the umbrella of a mandatory report, which interpersonal violence is not, again, unless you're dealing with the involvement of children or elders. All mediators have a responsibility to the mediation process. So one of your roles is to safeguard the mediation process, and that requires that the benefits are best achieved if mediation is conducted in an informal, balanced, and timely fashion. And in addition, the mediator is also responsible for confirming that mediation is the appropriate dispute resolution process under the circumstances of each case. In my personal opinion, I will tell you that I think this is one of the more undervalued, overlooked ethical obligations that a mediator has. I think that there's a large reliance on, if the court has referred the case to you, it must be okay to mediate. And if you have that, if that's how your train of thinking when receiving cases is, I would challenge you to look a level deeper. Not every case is reviewed before referrals to mediations are made. And even if the court was to review case files and make independent determinations about facts, perhaps not everything is known about the case may be available to the referring person. So you may very well, especially if you are a very busy practitioner, receive a case where there is an underlying safety and security concern, and you, the mediator, need to make sure that mediation is appropriate. And if it isn't appropriate, there's no harm in ending and concluding the mediation and bringing the case back to the court for the next steps in the process. Or if you're not in the court system, in mediating elsewhere, alerting the parties to other resources that may assist them. And while Tad and I are mediation cheerleaders from, dawn till dusk, not every case is best resolved in mediation. And we know that, and your leaders around the state know that as well. Okay, along with making sure that mediation is appropriate, there is a series of options for you to adjourn or terminate. And again, we see the word shall here, and shall is a must. You have to do it. So there's a number of items why you must conclude a mediation by either adjourning it or terminating it. And I will tell you that at CMEs, where we're live in person, I always usually go around the room and ask people to give me the definition of adjournment. And ultimately, a lot of people will adjourn that you are done, the case has closed. However, some people use adjournment as you are adjourning for today, you're coming back tomorrow. I tend to call that a continuance. So depending on what words you use, and words matter. So adjourn could mean close for the day. It could mean close forever. It could mean close and come back for another day, depending on your definition. Termination means that you, the mediator, or the court, in some circumstances, are concluding the mediation. And I just want to remind you that you would not report on your mediator's report termination as an outcome. The rules of procedure allow you to report full or partial agreement, no agreement, or the fact that the mediation has been continued. But to report termination, really refers back to our ethical obligations, and it definitely gives the court a heads up that something was wrong, because termination is not one of the options for reporting on it within the rules of procedure. So if you're reported termination, and you should cease that, and if the mediation has begun and you are ending it, it is a mediation that is ending in no agreement. If the mediation has never even started and there is something that prevents you from even kicking off the mediation, the appropriate response would be that no mediation has occurred. You wouldn't report no agreement if there was not a mediation. But again, you just need to be really careful not to report termination specifically on that report. So the first item under 10420B is that the mediation should be adjourned upon agreement of the parties. And I would imagine that seems very intuitive to you. Number 2 talks about adjourn or terminate if the mediation continuing it would cause unreasonable emotional or monetary costs to the parties. And if 2 parties were involved in some type of violence activity between them, domestic violence, stalking, dating violence, it might be that continuing the mediation would cause unreasonable emotional costs to the party. So that bears directly on what we're talking about. Moving on. Number 3, adjourn or terminate, goes back to if someone is unable or unwilling to participate meaningfully in the process. When we looked at self-determination was really a party is unable to exercise self-determination. Under number 3, you see that we also added to that is unwilling to participate. So number 4, you'll see number 4 and 5 don't offer you the option of adjourn or terminate. They offer only the single option of terminating. So you would terminate, stop, cease, and not reschedule a mediation which entails fraud, duress, the absence of bargaining ability, or unconscionability. You would also terminate the mediation if the physical safety of any person is endangered by the continuation of the mediation. So again, yeah, go ahead. I was just going to say some of these allow the adjourn or terminate. 1 has specifically adjourn and 2 have terminate. So you have a little bit of flexibility, but not a lot when you are concluding a mediation for these specific purposes.
Yeah, and Kimberly, I was going to point out that this is where the application of the continuing mediator education in interpersonal violence comes in handy for someone making these decisions and determinations, because these rules do not specify domestic violence only. It's if there is any situation which many of us can imagine situations that would be interpersonal violence, but not necessarily domestic violence, that would also implicate one of these three items. So that's where this the expansion of the CME for interpersonal violence, instead of just limiting it to domestic violence, will come in handy for mediators making determinations under this rule.
Right. Thank you, Tad. And let me give you a personal example. I won't tell you a whole story, but I have had the opportunity to terminate a mediation based on unreasonable emotional costs and duress. And quite honestly, I did not pick up on any of those items until I was in caucus with one party. And the party told me that the only reason that she was at the mediation or in court was because she was being stalked by the other person, and they were using the court system to see that person. And she also, alluded to the fact that she was nervous about being in the same room and feared for her security once she actually left the court building. So, and I unfortunately know that some of you out there listening to me have also had that very same type of situation. And in our mediation training, we do counsel that you would not want to continue that mediation, that you would want to make sure that one party was excused by the court in advance of the other party. And in this case, that's how the mediation was concluded. Each party was it was a small claims case, so they were brought before the judge independently without being put back into the same room. A small community, lucky enough to have free parking right behind the courthouse. So the deputies escorted the party out of the court, made sure that she had driven away before the other party was actually brought into the courtroom. So there are definitely safety protocols when you deal with people who express that they are under perhaps a threat of violence or feel that violence may occur to them as part of the court process. And it is a very serious matter when someone tells you that they are not safe or they do not feel safe. If you ever have that happen, and again, you're unsure of what to do, your ADR director, and again, I applaud the ADR directors around the state, please counsel with the next best steps. And I did not tell the deputies, just as a point of clarification, I didn't repeat the communications, although I believe that I could have under what the party was alleging. I just told the deputies that one of the parties had concerns over her safety and needed an escort to the courtroom and then back out to their vehicle. That's all the deputies knew. That's all they really needed to know. And then the other party was brought in. And unbelievably, though, the mediation did result in a settlement, which you might not think that it would have, but it did, which would then lend me to tell you a story, but I'm not going to necessarily do that right at this moment, only to say, though, that it was a very interesting case. So moving on, we do have another, I think this is our last mediator rule to look at, Rule 10.620, integrity and impartiality, that you should not engage or accept any engagement, provide any service that would compromise the mediator's integrity or impartiality. And this is, I think, a catch-all rule for the things that we do in mediation. And we put it in here just as a reminder to you to follow the ethical guidance that you have in the areas to keep people safe and secure in your mediations. We have had we might have had two or three, but we really have one MEAC opinion directly on topic to interpersonal violence. And we thought that we would share it with you. This question was also submitted by an ADR director for a mediation that she was concluding. And the question reads as, a party the mediation indicates either directly or indirectly that she or he is suicidal during the mediation session. Is the mediator permitted to disclose this information to an outside party like law enforcement, or is this information also considered to be confidential? Tad may have given you a hint to the answer a little bit earlier, but the MEAC opined that it is permissible for certified mediators to disclose mediation communications that are not confidential. In this example, the mediator may disclose information to the outside party, for example, a law enforcement officer. It's important to note that the questioner was the person who brought up the law enforcement officer. This wasn't just someone to report it to that the MEAC thought, oh, that's who you should report it to, because again, the statute is silent. on the exception to confidentiality on who you would report it to again. So, and the MEAC did opine that the violent threat, the caveat of threatened violence that is not confidential doesn't necessarily mean that you have to threaten violence against someone else. Threatening violence against yourself is also falls under the exception to confidentiality, and hence why they have opined that you could report it, and they have just codified that it could be reported to a law enforcement officer. The authorities, all of our Mediator Ethics Advisory Committee opinions have the authorities in which the answers were relied upon. In this one, you'll see that we actually covered all the rules that this opinion was based on: confidentiality, balance process, adjourn or terminate, as well as they looked at the exceptions to the Florida statutes that Tad went over with you. So that really wraps up our substantive information on the crossroads of mediator ethics and interpersonal violence, and is a good reminder to you that in this area you have not only statutory obligations to fulfill, if so desired, but as well as mediator ethical obligations. And that's why education in this area, ongoing education, is so critically important. Now, Tad, I see that we have a number of questions, and before we get to them in our closing slide, would you like to add anything else?
No, I was looking at the questions also. So whatever order you want to choose those in, we can certainly address them. If you want to. Cool. But there's some of them may be more appropriate to email later on because they're very fact intensive, but others may be more generally, an answer may be more generally appreciated.
All right. Well, you want to throw one out?
Oh, let's look at the one that says it's from Patricia. A frequently asked question, but always appreciate additional suggestions and input. What are some good ways to tell parties we are terminating mediation without signaling to them that we have concerns? For example, not notifying the alleged abuser that the alleged victim feels unsafe.
Well, I'll take a stab at that, and then we'll see what you'd like to say on it. When I have ended a mediation because of what I would call a defect in the mediation, that something is, and I'm working under the shall, I don't have an option, the rules say shall, I don't tell them that I am closing the mediation down because of X, Y, and Z. What I do tell them is I think that I've gotten to a point where I'm no longer able to help you effectively. And the best thing that I can do for you now is bring you to the next step in the process. So I kind of put it back on myself that I'm just not able to help them and move forward. I've only had to terminate a handful of mediations over my career. So I can tell you in the limited times that I've done it, I haven't gotten pushback from the parties. So that would be my default. Tad, do you?
Yeah, I mean, I agree with that. The main thing I would do is just simply, like you say, don't reference any details. I would not reference either party, put it on yourself, like you said, and just say, I don't think this process can help you. I don't think this process is appropriate, something very general like that, because neither one of those statements is untrue. You really, the caution I would say is that because if you start trying to dance around a reason by giving a reason or a pseudo reason or something, then you run the risk, of people not trusting the process and everything. And you want to make sure that what you say is true, and the best way is to let it remain very general, just like you did. So I like those answers, and from those answers being able to stress that the generalization and the fact that the process may not be appropriate, or that the process right now might not be appropriate, or something to that point. So
Okay. Who'd you like to go to next?
Let's think wait. Well, and kind of along that same lines is a question, would I be correct to assume that disclosure of the reason to the parties of adjourning or termination must be assessed on a mediation by mediation basis? Once again, with our answer just then, really, I would give as I don't want to say vague, but as general of a reason as possible. I would really not even necessarily weigh on a mediation by mediation basis. I would have and the other thing is a lot of times these decisions are made, on the fly, and because issues or facts or circumstances are coming up, and they're presenting themselves. So you really want to have somewhat of a for lack of a better term, canned answer, so that you can say it with confidence. And like I said, and it's true. And really, there's not a necessity for giving parties a reason, because generally these should be reasons that are out of one or both parties' control. And so, even if they know, it's not like they could go change it necessarily. I know that some people you may think, well, if I tell them this, they may come back into another session with a different mediator with a different attitude. But I would think that would be the small minority of cases, if you've got a real interpersonal problem, especially.
Mm-hmm. Okay. How about Jack's question? How do you report to the court that a case is not appropriate for mediation? And it's a trick question, and I wonder, because Jack likes to mess around with us, Tad. He's got a good sense of humor. So you wouldn't. Right. If the mediation has started in it, yeah, you're concluding it, it is a no agreement. The mediation has ended in a no agreement. You do not, the rules of procedure specifically say that you report agreement or no agreement without comment or recommendation. Now, I do understand, and I think we have another question about this, that it doesn't prevent perhaps an ADR proactive judge from referring the case back to mediation. I know that seldomly happens, but around the state, I have heard that happen. There is just no mechanism to give a wink, wink, side to the judge that says, something awful is going on here. Do not refer this case. However, repeat referrals of the same case to mediation are very rare. They do happen occasionally, but the court is not the correct place to report different items than what the court has suggested.
Yeah, the last one that I want to, I think, because we're running a little bit short on time, but one that I do want to address, because I actually thought about this during the presentation, is from Leo, and it says, now that we've established that virtual Zoom type mediation is acceptable and established in cases of fear by a party of violence by the other party, why not adjourn to a virtual type mediation? And that, that really, we've heard of, as far as the positive feedback that we've gotten, I mean the DRC and the mediation industry in general, the positive feedback that we've gotten is that for whatever shortcomings some people may think that Zoom has, one of the things it does is it really allows people to be potentially in their comfort zone, in their own living room, in their own home, and also not in this type case, not in the room with someone who they may physically fear. And it may actually facilitate someone participating in a mediation that, would not be able to do that in person. They may just be, too emotionally threatened to do it in person, but would, be fine to do it in Zoom. So as far as adjourning, yeah, I mean, I think that would be up to the parties. If
right,
if you
it
can
might,
get them to agree, I mean,
right, because they're both going to have to agree
right.
to go to another session, which they could totally do. I would hesitate though to if I would want mediators to understand though that people may still not feel comfortable mediating, even though they're in the Hollywood squares in two different places and they're not the physical violence or security is remedied, but the emotional cost of participating, and Tad, you were getting at that,
Yeah.
is still there. So
Yeah.
it's a and I appreciate Leo, I think, has attended most of our CMEs, and he's always got a good question for us. So thank you, Leo. I do have, Tad, we do have a question from Arthur about injunctions for protections, and we have a few minutes. So
yeah.
This is a little tricky because I have seen the court in open court acknowledge that there is a restraining order or order for protection, but then refer the parties to mediation in what will be a very small room and without 10 feet between the parties. I've also seen court orders that say, for the purposes of mediation, the order of protection will be suspended. So I have seen that done as well. But wouldn't you agree, Tad, if there is an order of protection and the court has not given a specific instruction, that the mediators need to make sure that they're mediating in an environment that doesn't violate that order?
Yes, I would.
Right. So that might mean Zoom, for example,
Right.
just like you said. It might mean if there's enough distance between the mediation rooms that you could do a shuttle mediation if the parties are willing to do that. But I, as a mediator, thinking about just my own personal security and safety, if the parties have an order that they're not supposed to be together, I don't know that I want to be in a room where they're together, even if the court has said in the order of referral that for the purposes of this mediation, that order is waived. So I would always like to know if there's an order of protection between the parties, not just for the parties, but for myself as well.
Well, and now that's a good point to probably end on. Is that there can be more than just two individual parties and the mediator in a room, and even if there are just two individual parties and the mediator, this interpersonal violence would be a concern not just between the parties but also with the mediator themselves. If there are other participants, attorneys, I know that sometimes parties really have and fester discontent against the opposing attorney because they see them as the ones who are focusing this process on them and everything. And so you really, it's this, it's to recognizing the interpersonal violence potential really is intended to also protect and to take steps to protect everyone in the room and to protect, once again, the process, self-determination, all of that. So I don't know if you want to add something along that lines, but I did think about that this is not just, one party threatening or attacking or whatever, being violent towards the other party. It really could potentially involve, the mediator and other participants in the room.
Absolutely. Absolutely. So great note, like you said, to end on. we do we have a conclusionary slide to remind us to do a few things. And one is to thank you for your participation. I believe this is our 6th or 7th CME in our series since we have started it on Zoom, and they've been very well received. So thank you to participating. We do have a number of questions that we weren't able to get to, and as we said, we promise that we will email you and correspond with you within the next week to get you the information that you've requested or respond to your comment or question. You will receive an email tomorrow from the Zoom platform, and it will include at the bottom, and I do ask you to scroll, it's not going to come up in your preview. At the bottom of the notice is the link to our course evaluation, and again, another link to the handouts. The handouts do contain a certificate of attendance. So if you need that for your CME history, it will be there. If for any reason you're not able to use those links or they're not working for you, we can always be contacted through the DRC's email, DRC mail, MAIL, all one word, at Florida Courts, that's plural.org. So if you have any follow-up requests from the CME, that is the best way to reach Tad and I. And it is extremely important to not only the DRC, but the state court system that we have good feedback on these programs. They help us for scheduling in the future, and also to know what is working best for our field. Today's topic actually came from Carol in the 7th Circuit, who asked us to spread our wings a little bit past ethics proper and include an IPV topic. So Carol in the 7th Circuit, here you are. We listened and we responded. And as a reminder, you'll get 1 hour of CME in both the Mediator ethics and the IPV categories. So we're offering somewhat of a 2-for-1 today, right, Tad? On this beautiful April day. So we thank you for being with us. This webinar will be posted on the court's YouTube channel for future viewing if you have colleagues who missed it. And we look forward to seeing you at our next educational event.
Thank you.
Have a good day, everyone.